Okay, so Donald Trump's hush money trial in New York starts tomorrow. This is the case where he's accused of altering business records to hide the hush money payments to Stormy Daniels. And of course, business records fraud in New York is a misdemeanor, and the statute of limitations have expired on the misdemeanor. But there's an additional law that says if the alleged violation of law was coupled with a previous violation of law to create gain, then it is escalated to a felony. And that's what New York has done here, only they claim that the hinging law that raises the misdemeanor to a felony is a violation of election campaign law. Now, I've explained this before, but here's the problem. I've explained Donald Trump should never have entered a plea to this case because he doesn't know what he's being charged with. They haven't told him what the escalating crime is, the other crime that makes this rise from a misdemeanor. It's an election law violation. Well, wait a minute. Was it a New York state election law? Because this trial is being held in the New York Supreme Court, and they only have jurisdiction over New York state law. And there was no New York state election. It was a federal election, not a state election. So no state election campaign violation can have occurred because it was a federal election. So what that means is they're alleging it's a federal campaign violation. Well, I'm sorry, but the New York state courts, including the Supreme Court, don't have jurisdiction over federal law. Not only that, but the federal government never prosecuted Donald Trump for any crime and has never charged him with any crime. New York is just making it up to increase the misdemeanor to a felony, to attack Trump, to interfere in the election, which is what this is all about. It's got nothing to do with paying money to a woman to go away and be quiet. Nothing at all to do with that. It's election interference. It's election interference. Nobody's ever been charged with this stuff before. It's just clear, obvious election interference. The state courts have no legal right to allege a federal crime that has never been committed, never been charged, never occurred, and for which there is no record. You can't make up a federal crime to leverage the misdemeanor into a felony and eliminate the statute of limitations, and that's what Bragg has done, DA Alvin Bragg in New York. That's what they've done in this case. Is they're making up a federal campaign election violation that has never occurred and isn't of record in order to get the misdemeanor escalated to a felony. So this is all going to be thrown out on appeal if it isn't won outright in the New York Supreme Court based on the, hey, you can't use federal law to escalate anything here, especially when there's been no federal crime, no federal trial, no federal charges, no federal indictment. There's no evidence at all of any federal election campaign violations that could legitimately be invoked to escalate the New York business records misdemeanor into a felony to try and convict Donald Trump and put him in jail to interfere with the election. So the trial tomorrow was a complete and total fraud. And what you want to look for is where is the information about what is the additional charge, the extenuating charge that lifted the expired misdemeanor into a prosecutable felony. Because when that comes out, that there is no other campaign election law violation, this whole case dies immediately. Because like I said, it's not a felony, it's a misdemeanor, and the statute of limitations expired. So the state court has no jurisdiction to use any election law violation allegedly because there was no state election, and the state court has no federal record to claim there was a federal crime committed in the election law to escalate the state misdemeanor to a felony. The whole thing should be tossed almost immediately.